saying, do I really need to be there for the full 2.5 weeks? We're saying to them, in every other court martial we ever have, we work with the government to say, hey, here's the shortest amount of time I expect I need this guy. 1 day, 1 hour. We can have him here a day early and a day later, but the government subpoenaed all these witnesses for 2 weeks, which is an unnecessary COVID risk. We don't expect we're going to get to them before the second week of trial if the government is genuinely representing that it's going to call 16 witnesses, and in light of all the other concerns. So we presented that for clarity. The government never objected. We never heard back from them. We discussed the witness issues in that 802 that followed from that email, and now I guess today the government's objecting to that, to the position that we've stated. So we certainly have no power to direct witnesses to come or not come, and that's the government's duty to get them there. But we are trying to be fiscally responsible and good stewards of the money here and of the Coast Guard funds in this case. So.
Sure. Okay. Go ahead, Chuck, also.
If I may, so just the government's expectation right now is we expect to conclude our case probably by Wednesday.
That presents grave concerns then about what they're trying to represent with their witness list. And again, this is about avoiding gamesmanship.
Sure.
If they think they can present 16 witnesses in 3 days, that indicates to us that they're not calling 16 witnesses. We just want clarity so that we can prepare and not be surprised at trial. And what we don't want is for the government to harden the defense witnesses against us by having them be around for 2 weeks for a trial we're not going to need them for the first week and a half. So we just want clarity to avoid games.
Sure. Trial counsel, based on my experience, I assume you went to the right. Some of those probably represent potential rebuttal witnesses. Is that correct?
Yes, Your Honor.
So my concern, right, is twofold. I understand the defense's concern. We cannot have folks just sitting around for 10 days with nothing to do and not being able to. The flip side of that I need to balance is that we also can't have a giant gap in the government rests and then it's Wednesday and we have members who are TAD as well waiting for 5 days because the defense folks aren't here. So those are my concerns. Defense.
Yes, Your Honor, and we echo those concerns. Those are our same concerns. We don't want people here longer than they need to be. We don't want members. We know how that goes. Members assume that it's something against the defense. It's just how the nature of the game. So we certainly don't want any gaps in the trial either. That inures to our detriment. But we just want candor from the government. We're not trying to make them expose their case. We're not trying to find out their strategy. We just want to understand who they're realistically calling. And even if it's their position that some of these are rebuttal witnesses, there's still no permissible rebuttal testimony from these witnesses who we've already objected to. So we just wanted to hash that out over a month ago, maybe almost 3 months ago now, when we originally objected and filed those motions. But here we are, weeks before trial, still trying to figure it out. We have no more clarity.
Okay, trial counsel, do you have any?
Our estimate right now is that we will conclude our case probably within about 3 days.
Okay, so again, government, back to you to tell the defense folks when to be there. I trust as officers of the court, if you're saying 3 days, then that you have defense folks. I don't think they need to be there over this weekend. Unless the defense wants them there. You need to try to thread the needle there. Again, if there's a little delay, that's okay. Half a day. But we cannot have gaps where we're waiting for folks to come in and arrive on time.
Yes, Your Honor.
Your Honor, briefly then, in response to Commander Tiley's position, the government knows now, it seems, as I stand here, that they're only going to be calling however many witnesses it takes to conclude by Wednesday. We just respectfully and I think very reasonably asked to know what that witness list is for their case on the merits. We understand that doesn't exclude anyone else on their list. It doesn't limit their potential rebuttal case. We just want to know, because the gamesmanship we've been referring to and the confusion and delay and distraction we've referenced in the motions months ago now was that we're stuck preparing for 16 witnesses witnesses who aren't going to testify, or 16 cross-examinations when we already have enough to prepare for. We need to be able to effectively prepare and not prepare in a way that wastes our time or that is misleading to our ability to prepare. So since Commander Tiley has stated that they already anticipate their trial will conclude by Wednesday, we'd just like to know respectfully, and I hope reasonably, by close of business today, what that witness list looks like for their case on the merits for the pure goal of allowing us to effectively prepare for trial.
Okay. So considering the fact that the defense has had a inability to speak with a lot of these witnesses, which is their right. There is no right for the defense to interview witnesses ahead of trial. But in light of that, I'm going to require trial counsel to get with the defense, have a conversation, and outline, of those 16 witnesses who you reasonably expect to be calling Monday through Wednesday.
Yes, sir.
Yes, Your Honor, nothing more from the defense.
Okay. Okay, counsel, is that all of the motions practice that we have to deal with on the record today?
Nothing further from the government, I guess with the exception of going over the voir dire.
Yeah. Ready to discuss voir dire? Defense? Yes, sir. Okay. So the government's proposed voir dire is entered into the record as Appellate Exhibit 225. The defense's proposed voir dire is entered into the record as Appellate Exhibit 226. Government's proposed instructions are entered in the record as Appellate Exhibit 227. Defense proposed instructions is Appellate Exhibit 228. The clenched charge sheet will be reserved for Appellate Exhibit 229. The draft findings worksheet is Appellate Exhibit 230. The draft sentencing worksheet is Appellate Exhibit 235. Okay. Government, turning to your, the way I'd like to do this is...
I really apologize, sir. Can we have a brief recess?
Yeah, sure. How much time do you need?
How much time?
Just quick.
5 minutes.
Okay, let's go 10. Court's in recess.
All right.
Carry on. Call to order at 1600. All parties present when the court's last recess are again present. During the break, we have brief 802, as I mentioned earlier, based on the inauguration and more specifically last week's event at the U.S. Capitol. The District of Columbia is under a very tight security posture, including closing several bridges and approaches into the district from points in Virginia and points in Maryland. I was provided a map by the DSO CO this afternoon, kind of giving me the lay of the land. We have ordered the members to be here at 0800 tomorrow. I am expecting that order to be complied in. I know that they have been communicating with, I believe, your staff, trial counsel?
That's correct, Your Honor. Ryan Ventosa has been in contact with
Okay, and she's in contact with the members?
That's correct, Your Honor.
And she, all of these members are assigned to Coast Guard headquarters, correct?
That's correct.
So they reside in the greater DMV area.
That's correct.
So I am sure, again, all of them, 06 and above, are cognizant of these issues.
Yes, Your Honor. My understanding, Your Honor, is they received this map yesterday.
Okay.
That we were referring to.
Okay. And so, again, we will be patient. Obviously, this is kind of an unprecedented situation for a commute. I will be patient with the members, obviously. I will be patient with council. There may be some unexpected issues that may delay us. Again, my goal tomorrow, if we can, is to get through group voir dire and individual voir dire and challenges. If that's a longer day, so be it. Again, realizing that Wednesday is completely not going to be available for court. So that is my intent there. Again, I acknowledge that this is not an ideal situation, but I also don't think that with the seniority of this panel and the schedule, that this is an impossible task. And certainly I have weighed any concerns to folks' safety. The fact that we're here on the Washington Navy Yard, a very secure facility, weighed heavily on my decision to hold member selection tomorrow, despite the fact that essentially all federal employees have been told to maximum telework. Again, the importance of this this trial and the schedule, and the fact that due to an earlier ruling, the court has bifurcated trial and we need to get these members, again, all senior 06s, orders cut, travel arrangements made. They, I'm sure, all have important jobs. They need to make plans to potentially have an extended absence from their primary duties. Their primary duty, again, will be, if they're selected, members of this court-martial, but, talking to their folks in their office. So all of those factors weighed into my decision to hold this member selection tomorrow and to require these members to report at 0800 on the Navy Yard. Okay. Okay, Councilor, the way I'd like to go through these voir dire questions is I will go through them, and I have already marked questions that I have concerns with. I will go through that with each side, and then again, after that's done, if opposing parties have objections to remaining questions, you can issue those at that time. Okay? All right. So, government. I am looking at your questions, and the first question is okay. I do have an issue with the word numerous. I know you've charged one specification with diverse. Numerous seems a little heavy-handed. A couple, several, if you could change that from numerous to a different synonym.
Yes, sir. With permission, I'll use the word several.
Okay. That's acceptable. Okay. Question number two, I have it, I think it says right away. I think immediately is a better word.
Yes, sir.
Okay. Explain to me 3, 4, and 5. And how that is not going too far into the facts of your case.
This is examples of what may be seen as counterintuitive behavior, and we have to know whether members will be able to understand that that not all victims act the way a person may intuitively believe that they should. So to get to any inherent bias that may be out there regarding how a victim should act, these questions would be necessary.
Okay, Counsel. Again, where we are in the rules is RCM 912. And I'm looking at the discussion section, which says the opportunity for voir dire should be used to obtain information for the intelligent exercise of challenges. Counsel should not purposely use voir dire to present factual matter which will not be admissible or to argue the case. I think questions 3, 4, and 5 all get a little too close to arguing the facts of your case, so I'm not going to allow you to ask those questions.
Yeah, sure.
Question number 6, you have wither, that probably just needs to be changed to whether. In the second line there.
Okay.
And my last issue is question 9. Seems to be kind of a nothing question. Do all members of the panel believe that officers within the organization are typically held in a position of trust? Do you think they're going to say no?
No, Your Honor.
Okay, so we're going to not ask question 9. Those are all my concerns, trial counsel. Defense?
I have those same concerns and 3 more, sir.
I'm sorry?
I have those same concerns the court just mentioned and 3 additional concerns as well,
Okay,
Your Honor.
yep, 3 more.
All on the second page, questions 7, 10, and 11. I don't see what bias 7 is getting at or how that is relevant to this trial. Is any member unable to consider that individuals may portray different personas depending on where they are and who is around? Number 1, I'm not sure what that question really means. I don't see how that's relevant to eliciting bias to intelligently exercise challenges for cause.
Okay, trial counsel, what are you attempting to elicit?
The position here is if they are simply looking at an 05 senior member of this organization, we have to listen to see if there's a bias to know whether they're going to give that person certain credibility or judge them in any particular way. What we're trying to elicit is, do they understand that people may put out one persona but have another persona?
And my question to the court would be, how is that ever even admissible evidence to the court-martial? I mean, it sounds a lot like character evidence, number 1. I'm not sure what evidence the government's going to present on that point. If they try to, that's never a conundrum these members are going to have. Am I biased about my ability to consider this inadmissible character evidence?
Again, the only standard that I'm dealing with here is found in 912. Can you articulate why this question goes to the intelligent exercise of challenges?
This would show that they have to be able to determine that they're able to understand that people may act a certain way in front of one entity in a different way in another. If they're unable to do so, they may, going back to the earlier question, assume that all 05 should be in a position of trust and would never commit such an act. We have to be able to show that if that bias is out there, we can ferret that out.
Okay, so your objection on question 7 is overruled. Defense, I'll allow that question to be asked. However, based on that, I don't think you need question 10. It's the same. It's getting to the same point. And then defense, what is your objection on question 11?
Fine with question 11 now that I think about it, sir. I'm fine with
Okay. Yeah, no, it's difficult.
I'm fine with question 11, sir. Let me just make sure I've captured what the court just ruled.
Yep.
You're allowing the government to ask question 7, but you're prohibiting them from asking question 10?
Correct.
Thank you, sir.
Okay. Yep.
Yeah, I'm sorry, if I could just clarify, make sure I'm not missing it. So questions 3, 4, 5, 9, and 10 are to be excluded.
That's correct.
Thank you.
I'd like the court to consider flipping 10 and 7. I'm looking at it and I'm understanding the trial counsel's argument as far as the ability to elicit bias. They can intelligently exercise challenges for cause. And the bias it sounds like they're concerned about is a bias, an inelastic ability to consider that officers could commit crimes. 10 seems to capture that bias much more succinctly and intelligently than 7 would. And it's a less prejudicial way of asking that question. 7 still presupposes that there's some weird underlying inadmissible persona conflict, which is not a permissible question to ask. That's just theory planting.
Okay. Defense, based on that, I agree with you. So you're not going to be allowed question 7. trial counsel, but you now can ask question 10. So the questions you are not allowed to ask are questions 3, 4, 5, 7, and 9.
Yes, sir.
Okay. Okay, defense. Okay, so I am looking at your questions 6 and 7. Really, my question is, how is question 6 and 7 any different or getting to any different information than your question 5?
I understand where the court's going with this. I mean, and the concern we always have is, obviously, the bias we're attempting to elicit here is clear. Just from experience, members may tend to respond to differently phrased questions. So asking a question the inverse may in fact elicit, say, a response from a member that wouldn't have responded to the question formed a different way. We're trying to make sure we're not missing that potential for bias and that ability to exercise that challenge, of course.
Yeah, let me give you a little insight to kind of my thought on voir dire, or how I like to do it. I always feel that group voir dire, when we start asking these follow-on questions, can become confusing to the members. I typically give you a wide swath and individual voir dire to drill down a little bit more on that. So I prefer you do those follow-ons more in individual voir dire. I don't really see myself limiting you for following up, but in the group setting, my experience is these follow-on questions then get folks confused. They think it's a different question, and then we have to go back and re-ask those series of questions. Just my experience, counsel. So I prefer you not to ask questions 6 and 7. Okay? I should state, I'm not going to allow you to ask questions 6 and 7.
Just have a minute, Your Honor. I'd like to read through them because we might suggest using either 6 or using 5 and suggesting you can keep one of them.
Pick one of the 3.
Yes, sir.
Yep. Okay, question 8C is very similar to my question 13 on the military judges question, so you're not to ask question 8C. And so 8D, what are you trying to get there as far as these members not being familiar with the terms? What are you getting at?
Well, again, it's one of those issues during voir dire, right, Your Honor, where that's in the military justice questions. You're talking about basic familiarity with the military justice system and referral and convening authorities. If members are raising their hands saying, yep, I agree with it, I agree with that, it's important to be able to test an individual voir dire their actual familiarity to what they're agreeing with. Because if a member is blindly agreeing to just something they actually don't understand, there's something to drill down on there. There's a potential bias, an explicit challenge for actual bias, or a challenge for implicit bias. It'll help us intelligently exercise our challenges for causes, in the sense that we're looking at members who essentially may be a little duplicitous during voir dire. Members that may be inclined to withhold accurate answers just because they want to go with the flow. That's important information that we gather during voir dire as well, and helps us intelligently exercise those challenges for course.
Okay, I'll allow you to ask it. Question 9 is very similar to my question 11, so you're not allowed to ask question 9. Question 13, Charlie.
I guess question 9 kind of sets up question 10, Your Honor. can.
You can say earlier the judge asked you.
So I guess I'm gonna add to question 10. Earlier, the judge asked you about this.
Yeah. Yep. Perfect. Okay. Question 13, Charlie, seems a little confusing to me at a read. I anticipate you getting some looks from the members because they don't quite understand it. What are you trying to get at? Just the presumption of the burden of proof?
Yes, sir.
They'll be instructed, won't they, on what beyond a reasonable doubt means?
They will, but we're testing their inelasticity to apply that instruction.
Okay. Okay, well, I'll allow you to ask it. I'm putting a lot of faith in this senior panel. Okay, 16 Hotel. I believe, as I was discussing with trial counsel, that question is too close to a factual matter and too close to you arguing your case. So I'm not going to allow you to ask 16 Hotel. Likewise, 17 Bravo and Charlie, I find are too factual, and thus you are not going to be able to ask those questions.
On those two, Your Honor,
Mm-hmm.
I mean, those aren't phrased in a factual manner. We're not planting anything there. We're just asking about scenarios with which a potential juror may have had familiarity, which would then... It's going to be an issue in this case. We're not asking it in relation to this case. Hey, do you agree that kids may hallucinate? Do you agree that if somebody hallucinates, then they're crazy, something like that? We're just asking, do you know anyone who's experienced hallucination? That allows us to test bias, because it's the same as asking, hey, in a sex assault case, do you know anybody who's experienced a sexual assault? Or in a robbery case, do you know anybody who's been burgled? That's what we're asking about, just the life experiences of these members. We're not asking them to subscribe to a theory. We're just trying to ask about life experiences which may then allow us to test for bias and intelligently exercise our challenges in the case.
Okay, I understand that, counsel. Again, the hallucination aspect, as you pointed out, is a factual matter in this case. I find that it's too factual, and it doesn't really mind any questions of implicit bias that you're seeking. So I'm not going to allow you to ask 17 Bravo and Charlie. Can you explain question 18?
Yes, sir. So, I mean, the header gives some of that away. Ultimately, what we're testing for in this subsection is the bias that some people experience. If they hear about an allegation of child sexual abuse, they're hardwired to believe, yep, that must have definitely happened. You wouldn't make this up. That question is just allowing us to get into this topic and test for that bias to. If there are members that agree, hey, say for example, animal abuse or something like that. Like these are things that make me so angry that I'm not going to believe that guy didn't do it. If you try and tell a Steelers fan that the Ravens are great, they're never going to agree with that, right? That's the intro to that bias portion that we're opening the door with that question.
Okay. All right, counsel. It satisfies my concern. Okay, so question 20. Why do you feel that you need to go further than the military judge's question there if they know anyone who's ever been accused? What do you... I guess I read that question in so what for bias, like how is that going to mine bias?
I'm just pulling up the military judge's questions as well, Your Honor, so I can actually address that.
I think, summarizing the question, right, the military judge's question is, is anyone in your family ever been accused of this? You're going a step further and asking, do you know anyone who's ever been accused of this? So why do we need to go that far?
Well, again, the judge's question exists because obviously we're testing for bias related to personal experience with these kinds of issues. It could be a close friend. It could be somebody that they've talked through these issues with because it's their best pal from college and they were accused of some kind of crime, or they had a crime perpetrated on them. So we're capturing those broader array of life experiences that could be just as impactful to somebody's bias and inelasticity when it comes to judging this case as, say, a close family member having experienced these issues.
Okay. Counsel, how is question number 29 not going directly to the facts of this case?
Are you in the computer?
So, the prospective member had an inelastic attitude towards considering the possibility that somebody could believe something that wasn't true, and all the research shows, all the literature shows, hey, people can believe things that never actually happened to them. If somebody is hardened and inured to that eventuality, those aren't good members for this case. They have an inelastic attitude towards receiving that kind of testimony, that kind of expertise. So it's not phrased in a way to touch on the factual issue of this case. It's phrased in a way to test the member's bias and to determine whether or not they are open to that eventuality. Because if they're not open to that eventuality, they have an inelastic attitude towards what essentially is a defense theory.
Okay. I understand your argument, counsel, but I'm not going to allow you to ask question 29. I had a question about question 31, but based on your last explanation, I'll allow you to ask question 31. 33, Bravo.
Are you waiting on me, sir?
Yes, I'm sorry. Can you explain what you're getting at for 33,
Sorry, you were
Bravo?
looking down. I apologize. Again, it's going to come up in individual voir dire to be able to test exactly what a member understands. So they'll be given instructions about judging the credibility of witnesses.
Okay, so I'll just ask you to ask that individual voir dire.
Understood, sir.
Yep. Okay, I find question 34 to be, again, too factual. I'm not going to allow you to ask that. Question 42 and 43, can you please provide some explanation? Again, these concerns are the same The question is, do you have any trouble accepting that a mother can cause a child to lie about something important? And does anyone have a hard time believing a mother could convince one of her own children to lie about something as serious as the allegations on the charge sheet in front of you? I mean, it seems like you're getting a running start to your opening statement.
Not really necessarily, sir, but I mean, we're going to have some mothers on the panel, we're going to have some fathers on the panel, and we're going to have some folks that have some really strong opinions about how mothers treat their kids. And that is a permissible area of bias that we need to test for to intelligently exercise challenges for cause. Is if there is a member who has an inelastic opinion towards this particular eventuality, they believe no way ever could a mother actually convince her own children to lie about something this serious. That would never happen. Like, yeah, sure, I could agree that maybe a mom might tell a white lie to her kids, but nothing is serious on this charge sheet. That's a legitimate challenge for cause in this case. And so it's a question we need to ask to test for that bias. It's not about planting a theme, but it goes to essentially their ability to evenly and especially consider the evidence. Because let's face it, if they answer yes to question 43, they're already convicted. That's the charge sheet.
All right, Counsel, you satisfied my concern. .45 on the other hand. So, again, 45, we're going to be cruising with these questions, and then you're going to hit them with, earlier, the judge read you the names of the witnesses, etc. However, the other witnesses and names and peripheral allegations may be brought up in the course of this trial, so we want to briefly discuss those. This case involves allegations of a conspiracy at the Coast Guard Academy. I mean, Counsel, where are you going?
Well, that's an allegation from Laurie Dowdell. And so what we have is a period of 10 years in potential involvement in this family. A lot of these members attended the Coast Guard Academy. If any of them heard of a conspiracy at the Academy, that could potentially mean they have some knowledge of collateral aspects of this case.
Okay. So
We can reword it.
I think that's covered in my general voir dire questions about, do you have any previous knowledge of this case? I'm happy to throw some verbiage in my question about regarding, the accused or something from the Coast Guard Academy, etc. I will put that verbiage in there to at least mine that part of their brain, but this is a little too much for me.
That's correct, sir.
46 is not going to be helpful for you. Does anyone know anyone at the Coast Guard Academy? So I'm not going to allow you to ask that. Going down to question 56. I think 56 Alpha and Bravo is sufficiently covered in my questions 26 through 29 from group voir dire. So I'm not going to allow you to ask questions 56 Alpha and Bravo. And the last issue I had with you, your questions, Counsel, is question 69. We just kind of talked about this in our issue regarding the witnesses, and I'm going to have a discussion with the members about the unique issues with this case. I think I'm going to draw that sufficiently out, whether they're irritated with this whole process, that they understand this is their primary duties. I'm going to have that conversation. I also don't want you to give them information that may actually not be accurate. So I'm not going to allow you to ask question 69. Regarding your pictures, I'm happy to allow you to do that. What I'd like you to do is just have the bailiff obviously hand those out at the time.
What I prefer to do, Your Honor, we can project them onto this hub, and that works pretty well, and usually better than the members looking at a piece of paper, especially with COVID mitigation members.
Are we going to be able to face it outboard to the group?
That'll turn any way I want it.
Okay. All right. That's fine.
Can we look, we kind of blew by 56, Your Honor. I just wanted to catch up.
You bet. So my question's 26. When I say my, from the bench book. Question 26 begins with, if sentencing proceedings are required, you will be instructed in detail before you begin your deliberations. I'll instruct you in the full range of punishments, from no punishment, the minimum lawful, to the maximum. You should consider all forms within that range. Consider doesn't necessarily mean that you would vote for that particular punishment. Consider means that you think about and make a choice in your mind, one way or the other, as to whether that's an appropriate punishment. Each member must keep an open mind and neither make a choice nor foreclose from consideration any possible sentence until the closed session for deliberations and votings on a sentence. Can each of you follow these instructions? Yes? No? The next question I would ask is, can each of you be fair, impartial, and open-minded in your consideration of an appropriate sentence? Called to do so? Yes? No? The next question is, can each of you reach a decision on a sentence if required to do so on an individual basis in this particular case, not solely upon the nature of the offenses of which the accused may be convicted? And then finally, is any member aware of any matter that might raise a substantial question concerning your participation in this trial as a court member? So why is that so substantially different that you need 56A and B?
Understood, Your Honor.
Okay. All right, trial counsel.
Thank you, Your Honor. If I could just follow up on number 6 and 7. What was the court's determination?
So I'm going to ask defense counsel between 5, 6, and 7 to pick one and go with it.
Thank you. And if we could take a look at it, you know, all my objections fall under either they're not relevant to bias and or they're cumulative to the military judges' voir dire. 10 and 11 and 12, Your Honor.
Okay, so 10 and 11 I think are fairly standard probing of, obviously the presumption of innocence. I think 10 and 11 are acceptable. So question 12 there, defense counsel. You're asking them if they've ever had to implement a legal burden of proof.
Yes.
And why are you asking that question?
Their personal experience and specifically their ability or inability to discard that personal experience should say they have participated at an ADSET board at some point in the past where they applied a low burden of proof. Should such a member have done that, then on individual board they say, yeah, I mean, I'm going to just treat this exactly like I treated that ADSET board, and go ahead, judge has instructions, but these seem like the same thing to me. Yeah, that's a challenge for courts. So they're testing that inelasticity to disregard previous experiences with legal burdens and follow the judge's instructions.
Okay, I'm going to allow you to ask 10 through 12. Trial counsel?
13C, that is an issue. We would just reassert that. We think that looks problematic.
Yeah, we had the discussion about that, and I did find it confusing. I'd like you to rephrase it, counsel. Can you rephrase it to something, again, less wordy, to say, do you understand that beyond a reasonable doubt, you have to find not guilty, if you think only it's possibly or maybe true. Just really zone in on the issue, right? You're trying to make sure that possibly or maybe true is not reasonable, beyond a reasonable doubt. Maybe you can just ask that. You agree that possibly or maybe true does not meet the burden of beyond a reasonable doubt.
Yes, sir.
Trial counsel?
Okay, Smith, at 19 seems very similar to 18.
Okay, I'm going to overrule that objection, counsel. I think that's a question that defense should be allowed to ask.
Number 26.
Okay, what are you trying to get there, counsel?
Goes to life experiences which may form the basis of inelastic opinions that a juror may or may not have, Your Honor. And it's directly relevant to testing a member's bias and intelligently exercising challenges for courts. If somebody has been exposed to literature about child abuse, if they've read a lot of literature about child abuse or documentaries about child abuse, and based upon that they have these opinions they formed, inelastic opinions, we need to be able to test those. That's what we're getting at.
Okay, so I'd like you to just change that. To either, have any of you ever I'm not going to allow you to ask at 26, counsel. I think that goes a little too far.
I mean, if I could be heard, I
Yeah, sure.
briefly just... So there are active documentaries out right now on various streaming platforms, Abstain, stuff like that. I mean, we're not asking about anything factual. We're not injecting any factual themes or theories from this case. I mean, they're going to look at the charge sheet and say, oh, this is a case about child sex abuse. Some of them might think, oh, I've been watching that documentary last week about this case about child sex abuse where this dad did these terrible things to his daughters. So I know that that's a terrible thing and that usually happens. We need to be able to test for those members who have seen these documentaries. It's part of the just the ether of public society these days is these hard-hitting publications and documentaries and films on these difficult topics, and a lot of people watch these and come away with pretty strong opinions, which are also called biases. I mean, when I do sex assault cases, I ask, hey, anybody familiar with the Me Too movement? That's a fine question. This is almost exactly the same as that. Well, no, it's exactly. It's along the same lines.
That's not the same bias.
So, I'm going to allow you to ask something. For some reason, I'm having problems with how you're asking it this way. I think it's almost too specific. Like, so, has anyone, recently watched any media or documentaries about, child abuse within the past year? I think that I get, I'm going to allow you to get to if someone in this panel, during, binge watched something, during shutdown on that. I think that's something a fair game to get to. I just want you to play with the words a little bit.
Yes.
For some reason, I'm having problems with like documentaries or read literature. Have you watched any Netflix series or whatever? I think you need to. Maybe it's the read literature. Maybe you're just being too formal.
As the State Farm guy says, so they're not programs; they're TV
Yes,
shows.
that's right.
So we'll do that.
Yes, correct. Okay, trial counsel.
And number 28, submit that looks a lot like the defense's case theory.
Defense.
Again, we're testing the inelasticity of a member who may be predisposed to just believe children no matter what. We need to identify those biases. If there's a member out there that says, hey, children would never lie, young Emmy is going to come here on this witness stand, nobody in God's creation can convince me that she could lie because she's a child, that's a bias we need to test for.
Okay, I think I test for it in question 27. So I'm going to sustain that objection. I'm not going to allow you to ask question 28. Trial counsel.
Object to question 31.
Okay, I'm going to overrule that objection.
I think that's 36, so it looks very similar to 35.
Okay, why do you need 36 on top of 35, defense counsel?
Make sure they will be blinded. Make sure they will be emotionally kind of blinded.
Well, I think they're different questions, Your Honor. 35 asks specifically about a member who will see an emotional child witness. 36 asks about, more generally, the ability of a member to consider external influences on somebody's emotions. If somebody is inelastic towards the idea that, hey, maybe this child is reacting like this because it was, say, for example, something she was told to do. Those are folks that have an inelastic attitude towards our ability to challenge that witness's credibility. Well, essentially what we're getting at here is we're testing for members that will be blinded by an emotional witness and unable to consider other evidence of witness credibility and appropriately implement the instructions the judge will give them on how to evaluate the credibility of witnesses. That's the only thing they care about. That's it. That's one and done. Somebody's emotional. It means it's true. That's an inelastic attitude towards implementing the judge's instructions when it comes to credibility of witnesses. That's what we're getting at there, sir.
Okay. All right, I'm going to overrule that objection.
Now, if we could take a look at numbers 41 through 43, again, we would submit that these look very similar to the defense's theory, and we're getting into facts of the case.
Okay, and we've already had this discussion with defense counsel on the record, so I'm going to overrule that objection and allow those questions to be asked.
Get to question 63.
Counsel? Defense counsel?
Try to catch up, sir.
Yeah.
Broadcasting possibilities isn't
Okay, this is testing for any personal conflict with this case, Your Honor. If we have a member who would receive this evidence and then has personal concerns about their own safety, that means they're distracted from actually devoting their full time and attention, as they're instructed when they receive their orders under this convening order. This is your primary duty, this is what you're focusing on, this is your job, is to look at this case, think about this case, do nothing but this case. If they're worried about their own personal safety during this case, that's a bias, that's a challenge for course, because they can't devote their full time and attention to thinking about the facts we're asking them to think about. Just because that may be evidence that comes out during trial doesn't make that an impermissible question. We do need to understand that if that were to happen, member X has an issue with that, and that makes them a bad member, because they're not devoted to this, their attention is going to be distracted. We need to know about that and challenge them for cause.
Okay, and you're referring to the Dowdells, the grandparents here, correct?
Yes, sir.
Okay.
I mean, not in this question, but I mean, I think that's what the trial
You may hear evidence that some witnesses in this case have intimidated or attempted to intimidate other witnesses. Is that the Dowdells, the grandparents? Lori Dowdell's parents? Or are there other folks that's referencing?
and Lori Dowdell herself.
Okay. All right. I'm going to sustain that objection. You're not allowed to ask question 63. Trial counsel, anything else?
Just object to question 64. The court covers.
Why are you objecting to that, trial counsel?
We believe the court will address this.
Okay, I'm going to overrule that objection. I'm going to allow the defense to ask those questions. Anything else?
Thank you, Your Honor. We have no further objections.
Okay. Okay, anything else to take up on the record today?
Thank you, Your Honor. There's nothing from the government.
Defense is going to ask for a stay, Your Honor, so we can file an extra with the Court of Criminal Appeals on the motion to recuse issue.
Moving for a stay of proceedings.
So we're just moving for stay of proceedings so we can do that.
Okay. Allow me to take a brief recess just to get the record in order. This court's in recess. Let's come back in 15 minutes, please. All right. Carry on, please. All parties present in the court last recess are again present. Defense counsel has requested a stay of proceedings in order to file an ex-writ to the Coast Guard Court of Criminal Appeals. Defense, your request for a stay is denied. The court will continue with proceedings tomorrow morning with member selection at 08:30. Is there anything further?
Thank you, Your Honor. There's nothing further from the government.
One additional thing I meant to bring up during the voir dire discussion, Your Honor, the cleansed charge sheet needs to be corrected.
Okay.
I'll pull it up right now. So currently, we're listed charge 1, violation of UCMJ Article 120B. That there shouldn't be parentheticals after that. It says rape and sexual assault of a child. Those need to be taken out, as do the obstruction of justice parentheticals. And I believe the judge can seal the cleansed charge sheet, but there should be a name in there, not initials, when it comes to the complaint witness.
Yeah, so I'm not going to order a name in there. I am going to order. I am going to order the parenthetical information to be removed from the cleansed charge sheet.
Yes, Your Honor.
Okay, counsel. Anything else? I need to know right now. We have a whole bunch of 06s that are being told to arrive at 8:30 tomorrow for 8 o'clock for voir dire at 8:30. Is there something that you know about now that is advisable to delay their arrival?
There's nothing from the government. No.
I'm a little concerned about the traffic. I mean, obviously, I'm going to be here as quickly as I can. My concern is that members arrive and they're told there's a delay, and I'm coming from a fair distance. And today wasn't too bad as a federal holiday, but DC traffic is pretty bad on the best of days, as you know.
Yeah, what I don't want to happen, counsel, that is all fine. What I don't want to happen is to have these members ready at 8 o'clock, just say magically it happens, 8:30, and then we have 17 issues to discuss on the record before we call them, and we're now actually not ready until 11 o'clock.
I don't anticipate any issues on the record. Maybe we want to make sure the cleansed charge sheet is correct. And
Okay,
take a look at
but
the
I'm really talking about substantive issues. None that you know right now.
None that I know right now.
Okay. Okay. Fair enough. All right. Then I will not disturb the members' instructions. Hopefully they'll get here at 08:30. 0800. Of course, unique situations, and everyone needs to be a little bit flexible tomorrow. That's going to be my theme with the members. So we'll take it as it comes. I'm an internal optimist. I hope tomorrow morning will be smooth. I hope tomorrow morning's commute looks a lot like today's, based on the fact that people have been told to stay away.
If I could just ask the court, I think earlier in the day you mentioned doing arraignments and entering pleas. Did you want to do that today? Or is that
Can we just do that first thing tomorrow morning?
Yes, sir.
If that's okay?
Yes, sir.
We'll do that first thing on the record, and then move right into members. Okay, hearing nothing further, this court is in recess until tomorrow morning at 08:30. Carry on, please. Thank you.
So we can finish this in 2 seconds with the internet. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second. Tell Tim to leave the Wi-Fi here for a second.